Good day, Crime Talk aficionados. Both the prosecution and the defense in the Bryan Kohberger matter turn over information regarding the alleged leak. Manhunt intensifies for an escaped convict in the Ozark Mountains. The Commonwealth concludes their case in the Karen Reed retrial amid some intense cross-examination. A woman was arrested at a Florida airport for allegedly assaulting a child on a flight. We have this day in legal history, and one of our first Supreme Court justices gives us our quote of the day, and then our dumb criminal of the day. Let's talk about it.
All right, lawyer.
Good day, Crime Talk aficionados. We have a great show for you. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't, like if you do, leave me a comment below, and hit that little bell for notifications. And yes, you can also listen to us anytime on any of your favorite podcasting apps. It's Apple. That's got to be the most popular one indeed. All right. Before we get to today's show, let me remind you to do a couple of things. First, go to crimetalksearch.com. Sign up for that background subscription service today, because when you do, you'll be able to do as many background searches as your heart desires on anyone here in the United States. And when you do that report, it is literally prepared while you wait, and it will be emailed to you, and you can get updates if there is new information that comes along. It automatically updates it for you. And you're going to get a report. And that report is going to show emails associated with an individual, cell phone numbers associated with somebody, their social media presence. And then you're going to find out if they have a criminal history. Are they married? Are they divorced? Do they have judgment liens? Are they on one of those sex offender registries, ladies and gentlemen? That's right. Their criminal history, one of the most important things you want to know about somebody. So go to crimetalksearch.com, sign up for that background subscription service today, and you're going to be happy that you did. All right, ladies and gentlemen, let's get to the docket. Let's open the record for Thursday, May 29th, 2025. And first on the docket today, Bryan Kohberger, the hunt for the leaker. Now, as you may recall, there was some new information that was released at the in regards to the Bryan Kohberger matter, in regards to that Dateline TV program that aired on May 9th, The Terrible Night on King Road. And as you may recall, on May 15th, the court in the Bryan Kohberger matter, well, let's just say they weren't pleased. And the judge issued an order back on May 15th. And it said, basically based on the sensitive information not previously publicly circulated that was reported during the recent Dateline TV program related to this case and the defendant Bryan Kohberger, it appears likely that someone has violated this court's non-dissemination order. Such violations not only undermine the rule of law, potentially by persons charged with upholding it, but also significantly impedes the ability to seat an impartial jury and will likely substantially increase the cost to try this case by extending the time it will take to seat a jury and potentially requiring a lengthy period of juror sequestration. Importantly, such violations potentially frustrate the ability to ensure both sides receive a fair trial, and accordingly, the court finds it is imperative to attempt to see that the source of such leak is identified and held to account, and that doing so is the best deterrent to future violations. Accordingly, the court finds it appropriate to exercise its discretion by entering this order. It is hereby ordered that all parties who at any time, past or present, worked directly or indirectly by employment, contract, consultation, or otherwise for or on behalf of the defendant Bryan Kohberger or his defense counsel or otherwise engaged in the investigation of the murder that are subject to the instant case on their behalf are hereby prohibited from deleting, discarding, overriding, destroying, altering, otherwise making unavailable any, whether electronic or in any material form, records, files, documents, metadata, messages, emails, text messages, direct or private messages, phone logs or logs of communications, regardless of whether made or kept on a work-owned or personal account, device, or messaging app that in any way relate to the document that the fact or substance of communications with third persons, including representatives of the media or other persons or entities outside of law enforcement, which communications in any way relate to, refer to, or concern the investigation or defense of Bryan Kohberger. The fact or allegations uncovered or reported to law enforcement or defense counsel concerning Bryan Kohberger or the investigation into the homicide that are the subject of the current or then potential criminal prosecution by Bryan Kohberger, collectively, documents, or singularly, a document. All such documents or materials or records that could potentially constitute a document, even if it is uncertain whether such meet that criteria, shall be preserved and must be protected from deletion, alteration, or loss until further order of the court. Feature on any device or account that is set to automatically delete or overwrite information that could be covered by this order must be immediately disabled. Further order that within 7 days, the lead defense counsel shall submit to the court in camera a list of all individuals within their team, past or present, who are known to have had access to any facts relating to the investigation of the defendant, but not limited to surveillance videos of suspect vehicle 1, the AT&T records for the defendant's cell phone, and the contents of the defendant's cell phone and other electronic devices and social media accounts, including internet search history, photographs, and any information associated with the defendant's Amazon account, or any information referenced in the above-mentioned Dateline episode regarding the case. Counsel is further required to provide a copy of this order to all such individuals and documents that are done so. Failure to comply with this order may be a basis for a finding of contempt of court and such other civil and criminal consequences as may be appropriate. Now, this order related to the defense counsel. Don't worry, the prosecution had one as well. Now, I'm not going to go into that all over again, but it does note just a little bit differently that such violations not only undermine the rule of law, potentially by persons charged with upholding it, but also significantly impede the ability to seat an impartial jury and will increase the cost to be borne by the taxpayers of Latah County to prosecute this case by extending the time it'll take to seat a jury. Same thing, everything else has to be required. So, in accordance with this, on May 22nd, which was obviously last week, but we just get access to it today, the defense notice of compliance comes now, Bryan Kohberger, by and through his attorneys of record, and hereby provide notice that the defense has submitted a letter with attachments for an in-camera review to the court in compliance with the document and records hold order dated May 15th, 2025. Prosecution. Notice of compliance. Come now, State of Idaho, by and through the Latah County prosecuting attorney, and hereby provide notice that in response to the court's documents and records hold order dated May 15th of 2025, that the state has lodged with the court for an in-camera review an ex parte letter with attached exhibits. The state has provided the court with documentation of distribution and receipt of the court's order to involved agencies as ordered. So, Judge Hippler took this matter very seriously. That program aired on May 9th. By the 15th, he says, hold your horses, everybody, and nobody better delete anything because I'm going to find the source, because this is going to affect the cost, the duration, and the potential ability for Mr. Kohberger to get a fair trial, as well as the people to get a fair trial. And everybody's entitled to a fair trial, both the prosecution and the defense. So to take it that the judge was a little less than pleased would be an understatement. So he ordered the prosecution and the defense to go to everybody. And he even ordered at some point the possibility of a special prosecutor, particularly if somebody on the prosecution side has leaked this information, to be prosecuted, or at a minimum be held in contempt, which carries the potential of jail. So they would be entitled to a defense attorney and a hearing to see if that's actually what took place. But somebody's in some serious trouble if they are found. So they are hunting the source. And this Judge Hippler, somehow I think by what I've seen from him in court, he's going to find somebody. And the question is how is he going to handle it? Now, the question also is have the prosecution found who did it? Was there somebody on the defense side who did it? We don't know now, do we? Oh, I wish we knew. Oh, I hope there's going to be orders, because clearly it got leaked and somebody didn't comply with the court's order, and they were all subject to that court order. Although, you'd probably say, I'm not a direct participant in this case, and so therefore, you couldn't be involved in, if it's some investigator down the road. My guess is it's law enforcement. Somebody in law enforcement thinks the process isn't going long enough or quickly enough, and that's probably why they did it. Why is it taking so long? Everybody knows he's guilty. Let's just, get it out there. Now, I certainly appreciate it. I wish we all had access to the discovery, but that usually doesn't happen until the case is over. And if there is a gag order, you have to comply with it. It's a court order. If you think it's not a valid court order, then you need to challenge it, but you don't get to ignore it. And so somebody ignored it, and somebody is going to be in big trouble. The question is whose side did it come from? My guess is prosecutor did it. Why? My experience is anytime I've ever had a case that was mistried, you know who did it? It wasn't the lay witness that said something they weren't supposed to say. It was always the cop that testified, that wants to get one little jab in because he doesn't like the defense attorney, he doesn't like the defendant, and they say something they know they shouldn't say, and a mistrial is declared. And this could have significant consequences, ladies and gentlemen. One, it could cause a continuance that the defense has asked for, although it seems a little unlikely at this point, the way the court is moving forward, that is going to be granted. But it'll certainly be an appellate issue as well if it isn't dealt with appropriately. And if there isn't some sanction to the leaking party, once again, it's an appellate issue for the appellate people if Bryan Kohberger is ultimately convicted for any post-conviction relief type of matters. So they need to get to it. I get it. Nobody would love to see all of the information in the Bryan Kohberger case more than I would, but we got to comply with the court orders. That's the law. Got to follow the law. All right, next on the docket, the manhunt intensifies for the escaped convict in the Ozark Mountains. That's right, Grant Hardin, the now 56-year-old former police chief. You heard that correct, ladies and gentlemen. Police chief escaped from the North Central Unit in Calico Rock, Arkansas, back on May 25th of 2025. Now, he was convicted of first-degree murder and he is serving a combined 80-year sentence for the 2017 murder of James Appleton and a 1997 in Rogers, Arkansas. Now, he's known as the Devil in the Ozarks. Now, Hardin's escape has triggered a massive manhunt in the Ozark Mountains. Hardin executed the escape at approximately 2:55 p.m. by impersonating a correctional officer wearing an imitation uniform and adopting the demeanor of prison staff. He exited the medium security facility after a prison officer opened a secure gate without verifying his identity, and Hardin was seen pulling a dolly which appeared fully loaded, aiding in the disguise. Now, the escape was undetected for at least 30 minutes, and authorities announced it publicly 2 hours later. Well, local, state, and federal law enforcement are scouring the Ozark Mountains, focusing on the region's vast forest, abandoned cabins, and nearly 2,000 documented caves. Authorities are using canines, drones, and helicopters to search the cave-dense terrain, which experts described as ideal for concealment. Now, Hardin, familiar with the area's cavern system, is considered extremely dangerous. Like I noted, he has a criminal record for the 2017 murder of this James Appleton, a Gateway Water Department employee, for which he received a 30-year sentence, and the DNA later linked him to a 1997 rape, resulting in an additional 50-year sentence. Now, Hardin's brief law enforcement career included stints at the Fayetteville, Huntsville, Eureka Springs, and Gateway police departments, marked by allegations of excessive force and misconduct. Anyway, residents of the Ozarks are on high alert, with sheriffs urging people to lock their homes and vehicles and report suspicious activity. The escape has drawn a comparison to the manhunt of the bomber Eric Rudolph, who evaded capture for years in similar terrain. Now, locals, including some business owners, say that survivalists with knowledge of the region's caves could hide out, indefinitely. Authorities remain confident, though, that Hardin is still in the area, prioritizing searches of caves and abandoned structures. And the Arkansas Department of Corrections is reviewing security protocols at their facility to prevent future escapes. Good call, Arkansas Department of Corrections. Anyway, the investigations continues to determine how Hardin acquired his disguise and whether he had assistance. Could he be? Maybe any female guards, any female deputies there at the correctional center missing? Yeah, remember the sheriff deputy that gave it all up for the guy on death row, taking him to his doctor's appointment? I think I'd check any romantic relationships there. Anyway, the manhunt for Hardin underscores the challenges of searching the rugged Ozarks, and as police intensify their effort, the community remains vigilant, hoping for swift apprehension of such a dangerous fugitive. I don't know. Obviously, bad man, pled guilty to murder, and got two of the big three ones there, right? Two of the three kind of indicator not a good guy. A little troubling that he was able to work in law enforcement as long as he did. But then on the other hand, you're kind of like, run, Forrest, run. But yeah, go for it. I mean, kind of interesting, you know? I'm sure he'll get a fan page real soon. Women will be wanting to date him. I can see the cycle beginning all over again. Next on the docket, the Commonwealth rests their case in the case against Karen Read. That's right. Massachusetts has rested its case against the retrial of the high-profile case of Karen Read, marking the culmination of its presentation against the defendant, who is accused of striking and killing her boyfriend, Boston police officer John O'Keefe, with her Lexus SUV back in January of 2022. Now, the day was marked with some rigorous cross-examination of crash reconstruction expert Justin Welcher and the introduction of a significant piece of evidence, a televised interview clip from April of 2024 in which Read speculated about the events surrounding Mr. O'Keefe's death. So after excusing Welcher from the witness stand, the prosecution played a clip from an April 10th, 2024 interview that Karen Read gave to ID docuseries. In the clip, Read is heard contemplating whether she could have inadvertently struck O'Keefe as she left 34 Fairview Road on January 29th of 2022. She says, quote, "So I thought, could I have run him over? Did he try to get me as I was leaving and I didn't know it? I've always got my music blasting. It's snowing. I've got the wipers going, the heater blasting. Did he come and hit the back of the car and I hit him in the knee and he was drunk and passed out and asphyxiated or something?" End quote. Now, Read said that in the interview. She further recounted discussing these hypotheticals with her attorney, David Yannetti, asking, what if I ran his foot over? Or what if I clipped him in the knee and he passed out or went to care for himself and threw up and passed out? This is all according to Read. Yannetti responded that such scenarios would simply imply some elements of culpability. You mean like you were drunk, you hit somebody, you injured them. Yeah, like vehicular manslaughter. Yeah. Anyway, it was reported there was no visible reaction from the jury as the clip was played. And following the presentation of the evidence, the Commonwealth announced it was resting its case. The judge informed the jurors that this signified the prosecution had completed presenting its evidence for their consideration. The prosecution did, in fact, rest. There was some pretty intense cross-examination of the expert. Now, the morning session was dominated by a contentious cross-examination of Judson Welcher, a crash reconstruction expert from Aperture, by defense attorney Robert Alessi. Now, Alessi's questioning focused on challenging the reliability of Welcher's analysis, particularly regarding the suspension height of Read's Lexus SUV, the accuracy of ring camera footage, and the origins of glass fragments found on the vehicle's bumper. Now, Alessi pressed Welcher on the suspension height of Read's Lexus, a critical factor in determining whether the vehicle's rear spoiler could have caused O'Keefe's injury. Welcher admitted he did not have measurements from January 29th of 2022, the date of the incident, and relied instead on the measurements taken 2 days later in the Canton Police Department. So you don't know what the suspension ride height at 34 Fairview was on January 29th, do you? Alessi asked. Correct, Welcher responded, confirming he only had the data from February 1st of 2022. Alessi further questioned the tolerance of the SUV's air-based hydraulic suspension system, suggesting it could vary up to 5 inches. Welcher expressed skepticism, stating he believed the tolerance was closer to 1.25 inches, but would need to verify. When asked if he documented the suspension level during testing, Welcher emphasized that his team matched the vehicle height to the photographs from the Canton Police Department, stating, "I don't care what the numbers are. I care that the height is the same. Individuals in the courtroom noted that 14 jurors took notes when Alessi highlighted Welcher's assumption that the suspension height at the time of the alleged collision at 1 Meadows Avenue matched the later measurements. Alessi also scrutinized Welcher's using of the ring camera footage from O'Keefe's home at 1 Meadows Avenue, pointing out that the camera in place on October 2, 2024 during the aperture analysis differed from the one present on January 29th, 2022. Welcher confirmed he was aware of the difference but did not measure the positional variance between the two cameras, relying instead on the video and laser scans to conduct a reverse camera analysis. If the starting point is wrong, could the rest of where you go be partially wrong? Alessi asked, which Welcher conceded. Possibly. Now, Alessi argued that differences in camera models and potential distortions could affect the accuracy of Welcher's measurements, a point that Welcher countered by asserting that the errors were within an acceptable range. Now, the cross-examination also delved into the glass fragments found on the rear bumper of Reed's SUV, and Alessi questioned whether Welcher could definitively link the glass to the drinking glass allegedly held by Mr. O'Keefe. Welcher acknowledged that while a broken bar glass was photographed near O'Keefe's body, he lacked forensic evidence confirming a connection. Now, we have pictures of a broken bar glass in the snow near where Mr. O'Keefe's body was, and we have the glass fragments on the rear of the bumper. That's the extent of my knowledge on the correlation, Mr. Welcher testified. Alessi then pressed further, noting that Welcher did not review all the forensic reports, potentially missing critical data about the glass. The cross-examination was marked by a heated exchange between Alessi and Welcher, with the judge intervening at one point to allow Welcher to complete his answers. Alessi accused Welcher of distracting the jury, prompting a sharp rebuke from the judge. Mr. Alessi, please. The courtroom observer noted that one juror appeared entertained during these tense moments, with the same juror laughing after a particularly contentious exchange. Well, Welcher's relief was palpable when excused from the stand as he exclaimed, "Oh my God, thank you, Your Honor," eliciting laughter from the jury and the courtroom. Your Honor, this whole argument is absurd, Alessi argued, asserting that Reed's constitutional right to cross-examine was being undermined by the prosecution's objections. The prosecutor, Mr. Brennan, countered that Welcher conducted his analysis independently and did not rely on Paul's report or Scortobello's undetermined cause of death conclusion. Brennan accused the defense of attempting to pit one witness against another to create the appearance of inconsistency. The judge sided with the Commonwealth, prohibiting Alessi from pursuing questions related to the Paul or Scortobello, stating, "That's my ruling. Let's bring in the jury." Anyway, during redirect, Special Prosecutor Brennan sought to reinforce Welcher's credibility, asking if he had concerns about photoshopped images or altered suspension settings in his analysis, and Mr. Welcher responded no. Alessi briefly returned to the topic of confirmation bias, questioning whether Brennan's redirect focused solely on data. Welcher's response remained consistent, and Alessi concluded his questioning shortly thereafter. Anyway, the Commonwealth has, like I said, rested its case. Obviously, the pivotal moment in the trial, shifting the focus on the defense presentation. Now, remember, the defense never, ever has to present any evidence. And frankly, if the defense feels as though the prosecution has not met their burden, the defense can rest tomorrow morning when they get their case going, if they choose to do so. I can tell you from a defense perspective, that's what I prefer. I've won more cases when I get up and say they failed to prove their case beyond a reasonable doubt, ladies and gentlemen, and let's talk about why. Now, I don't think the defense is going to do that. I don't think Karen Reed would allow that to take place. There'll also be the motion for a judgment of acquittal, which will promptly be denied because the judge is not supposed to insert themselves as a 13th juror. This will be decided by the jury. Now, remember, the jury, they're smart people. They're everyday people, ladies and gentlemen. And whatever decision they come back with, we will respect it. All right? This is probably one of the most important things that these jurors have ever done in their particular life, not to minimize their life experience, but this is serious stuff. And yes, sometimes when you deal with kind of everyday decisions where people's liberty gets, at stake, it becomes somewhat routine. But if you're not used to that, it's a big, big deal, ladies and gentlemen, and jurors want to get it right. Nobody wants to convict an innocent man, or in this case, an potentially innocent woman. And so they want to get it right. And if the state has proven their case beyond a reasonable doubt, it is their legal and moral obligation to find Karen Read guilty. But on the other hand, if the prosecution has failed to prove the case beyond a reasonable doubt, it is the juror's moral and legal obligation to say not guilty as well. And that's okay. That's the way the system works, ladies and gentlemen. And here's the beautiful thing. We'll all find out together. Anyway, so join us tomorrow morning because we will be carrying the case live for you. And I don't know. Well, if depending on how things go, I'm going to move some things around. I'm going to try to sit in during the case as well. We'll see how that goes. Anyway, we'll see. Like I said, Karen Read, given the presumption of innocence, she doesn't have to prove herself innocent. We'll have to see. I think it's going to be a tough sell at this point, though, that to use her own words, the data is what it is. We'll have to wait and see. All right. Next on the docket, Lori Vallow appears for her pretrial conference for her third trial. That's right. Today, a significant development occurred in the Lori Vallow second Arizona case. It's her third one because remember, she was convicted for killing Tammy Daybell and JJ and Tylee, her children. Anyway, this case involves another charge of conspiracy to commit first-degree murder related to the attempted murder of Brandon Boudreaux, her former nephew-in-law. Anyway, there was a last-minute hearing that was held there in the Maricopa County Superior Court before the presiding judge, Jennifer Green, to address Vallow's motion to remove Justin Boreski from presiding over the case. This was her second attempt to have Judge Boreski recused from the matter. Anyway, Judge Green denied the motion, ensuring that Judge Boreski will remain on the case, and jury selection for the trial is scheduled to begin this afternoon, with opening statements expected to start as early as June 2nd. So just next week, ladies and gentlemen. Now, the prosecution is led by Trina Kay. She responded to Miss Vallow's motion and basically said it's frivolous. And basically, the state's ready to proceed. They plan on calling up to 22 witnesses, including 7 from the Gilbert Police Department. Obviously, these developments indicate the trial is moving forward as planned, despite Ms. Vallow's effort to alter the judicial oversight. Now, ladies and gentlemen, this is probably one of the more common questions you get, particularly when you have a no-nonsense judge. Well, how do we get rid of the judge? Well, do you know the judge? Are you related to the judge? Have you ever done any business transactions with the judge? No. Okay, well, we're not going to get rid of the judge. Well, he sentenced me on my other case and he doesn't like me. Okay, unless he said you're a horrible human being and you have no reason to live kind of stuff, they're going to stay on the case. All right? Unless they've said something that they're predisposed to some sort of sentence in the case, they're going to stay on the case. You don't get to pick and choose your judge just because you don't like them. So many people think that. It's kind of like a change of venue. Well, what about change of venue? Because this is a tough jurisdiction where I, allegedly committed this crime in. These juries are tough on crime. Yeah, so are the judges. Just like the juries don't like it, judges don't like it either. Well, we need to change venue. Well, there's no reason to change a venue. Change a venue is only when you can't get a fair trial here. And frankly, nobody knows about your case. There hasn't been so much information out there about your case, like Bryan Kohberger type of case where they're going to move it because the town is so small. Everybody's forming an opinion. Chance of getting a judge off your case, slim to none. You got to have something really straightforward. I can remember we had a civil case. It was involving some people that had engaged in political activities. There was a civil lawsuit, and let's just say the judge made some statements that were completely contrary to the statements or the political views of the people that we represented. and filed a motion to recuse. And judge is like, nope, I can be fair and impartial. Just because I don't like your clients, I think they're, wackadoos or whatever. I can be fair and impartial. And ultimately, the judge threw out the case and as a directed verdict. So, good judges call balls and strikes. And just because you don't like the way they're, calling that strike zone, as long as they're calling balls and strikes, that's what you get. So Lori Vallow, good luck. I'm sure the judge is going to be just as happy to see you as you are to see him. Next on the docket, a Florida woman was arrested at the Orlando Sanford International Airport after allegedly striking a child who insulted her during a flight bound for Maryland. That's right. Christy Crampton faces charges of child cruelty by abuse without great bodily harm, according to the police. Now, the incident detailed in the probable cause affidavit prompted the removal of Miss Crampton and several others from the aircraft before the aircraft took off. The juvenile victim informed police that he had been upset after his phone was confiscated and admitted calling Miss Crampton fat while pushing her arm off the armrest, claiming she was taking up excessive space. Now, according to the arrest affidavit, Miss Crampton responded by striking the child in the face. These two witnesses, there were two witnesses that corroborated the account of what took place, with one reporting that Miss Crampton hit the child with her fist and a water bottle before allegedly slamming his head against the airplane window. The woman was not correcting the child. She was abusing him, one witness said. Anyway, police detained Miss Crampton at the gate where she claimed the child had been rude and disrespectful to her. The relationship between Miss Crampton and the victim remains unclear, but Miss Crampton appeared in a Seminole County court and was released on a $10,000 bond. The judge issued an order prohibiting her from having contact with the victim. I would say that's going to be no problem. Sticks and stones, ladies and gentlemen. I get it. Sticks and stones may break my bones, but names will never hurt me. I've been called lots of things, ladies and gentlemen, and one of them has been fat over the years, but I never beat up a child because of it, even if they deserved it. And, let's face it, times have changed. When I was a kid, if you had been rude to an adult, you got smacked across the head, right? Your parents would be like, how dare you be disrespectful? Now wait till I get done with you. Don't do that anymore. Maybe if we did, this young Ute of America would not have been so rude to Miss Crampton. Anyway, next on the docket, this day in legal history, May 29th, 1790. That's right. Rhode Island became the last of the original 13 colonies to ratify the United States Constitution, establishing the federal legal framework, including courts and criminal law for treason. This solidified the United States judicial system as well. Then on May 29th, 1896, civil rights activists were organizing against Plessy v. Ferguson decision, which upheld segregation, laying groundwork for future anti-discrimination lawsuits. And then on May 29th, 1930, federal agents raided illegal speakeasies in New York, targeting organized crime. Obviously, these efforts exposed corruption and supported Prohibition's eventual repeal. And then what we have is our quote of the day. It comes from John Jay, the first Chief Justice of the United States Supreme Court in 1794. The jury has the right to judge both the law as well as the facts in the controversy. Now, this quote underscores the significant role jurors play in the legal system, emphasizing their authority to evaluate not only the evidence presented, but also the applicability of the law itself and the facts to reaching a verdict in the given case. And finally, ladies and gentlemen, our dumb criminal of the day. A man was arrested after he claimed to be a San Antonio police officer while attempting to steal items from the store. Please meet Emilio Caraman, who was arrested trying to steal from a Home Depot on Monday. Now, after store employees confronted him, Caraman told them that he was an undercover detective for the San Antonio Police Department. Well, needless to say, store Employees didn't believe Mr. Caraman. They called the San Antonio Police Department. Officers arrived at the scene, debunked Mr. Caraman's claim, and ultimately took him into custody. Anyway, Mr. Caraman was charged with impersonating a public servant and stealing between $100 and $700 worth of property. There you go, ladies and gentlemen. You almost can't make this stuff up. I was stealing, but it's okay. I'm a police officer. Oh, well, go right ahead and steal. That's okay. If I had known, we would have helped you out. Can I get you a buggy? No. Of course they didn't believe that. All right, ladies and gentlemen, that's all we have for today. Hope you enjoyed the show. We'll see you next time. And remember, the Constitution matters.